punishment for a C. A B punishment, the punishment for a B is a little bit more. Whereas a C is a year and a day to 10, a B is 2 to 20. That means 2 years is the minimum you can get for a Class B felony. 20 years is the maximum you can get. An A felony has an even stiffer range of punishment. An A felony, as a general rule, is 10 to 99 or life. That's how they say it, 99 or life. And I don't know why they say it that way, because I honestly think the way it's calculated, 99 years is considered to be more than life. But it's 10 to 99 is an A. There are, with the range of punishment with each one of these, there are what we call sentencing enhancements. What people normally think about is you hear folks talk about 3 strikes rule. 3 strikes and you're out. Especially a lot of baseball fans, you hear that, and I think you hear people talk about that in federal court. That's not really the way the Alabama system is set up when it comes to habitual offenders, and that's what we have the Habitual Offender Act. So let's say you have a C felony. What we just talked about was that in a C felony, your range of punishment is a year and a day to 10. If you have a C felony with 1 prior felony offense, then instead of a year and a day to 10, it's 2 to 20. If you have a C felony and you have 2 prior felony offenses, it becomes 10 to 99. 3, 15 to 99. It goes up. So what the statute does is it looks at the nature of your offense, and it looks at your prior criminal history. And there are charts and graphs, and it tells what should happen. And every lawyer has to be familiar with that, especially new lawyers or lawyers who are just starting out. We talked a second ago about my first trial. Well, it was also my first criminal defense trial. And I left the city attorney's office on a Friday. And I went over with my partner at the time, Lee Daniel, on a Monday. I had previously been a clerk for Judge Jim Smith, and he appointed me to a couple of cases. So Tuesday, I get appointed a case, and I'm happy. I'm looking at it. Robbery 1. My client is alleged to have gotten a gun, gone through and robbed some people and did stuff. Very first case I had. They don't start me with anything simple. They start me with a robbery. So it's set 3 days later for trial. I go in and I just know the judge is going to continue it, and I come in with my button. Well, Your Honor, I was just appointed on this a couple of days ago, and we need our continuance so I can meet with my client and get prepared. And the judge goes, well, it's a 2-week docket. We won't start your trial until next Monday. So I get in there, and I think, oh, my goodness. And it doesn't hurt that my client's scared, man. I go visit him in the little room they used to have over at the jail, and the guy was like intimidating and imposing. And my last lawyer messed me over, and now you're in here, and you're a new lawyer, and you can't do nothing for me. And I'm sitting in there, and I'm scared, and I don't know what to do. So I do all this work, and I'm prepared, and I go in there, and we've talked about the range of punishment, and I sit down, and we come to the trial day. We go up there on the trial day. And then that's when somebody tells me he has 3 prior felonies. So instead of him looking at a Class A felony, 15 to 99, he's looking at life or life without. Huge difference. Instead of 10 being his minimum, it's life. And here I am. I didn't even know. Luckily, we ended up getting a not guilty on that one, and it was a good verdict, but it's scary. That's one of the things a lawyer has to know. And with that week's time, I didn't discover what his range of punishment was. So I probably informed him wrong, but we won the case. So it's a mistake of a new lawyer, and it happens. But you have to know that each time your client has a prior felony, and the DA's office will assert them, and they had asserted the priors in this case. They had sent notice to the previous attorney, but of course, I wasn't the previous attorney. And I'm getting caught up in all these things, and we got it, and it had a good result. But once again, this was one of those cases where he got off on this huge part, and he had like a joint or something with him, I think, and this guy ended up getting a year in jail for the joint when he was looking for the life and looking at life, and he filed a bar complaint saying that I was ineffective. And that, you know, I actually kind of framed that. You get a case, and you've been on it for a week, and you get a guy off of attempted murder where he's looking at life without, and he hasn't spent a year in jail when he's already done 8 months. It was, I considered it a win, and the appellate court tended to agree with me. But that's one of the enhancement provisions. There are others. If you commit a felony when you use a firearm, the law does not like firearms to be used in cases. I understand we like our guns, but we don't like our guns when they're used to commit a felony. We don't like them when they're used to commit a robbery. We don't like them when they're used in the commission of a burglary, a rape, a murder, whatever. You know, if you commit a Class A felony while you use a weapon, your minimum punishment jumps up to 20 years. And that's just by statute. That's one of the things we do. If you are a drug seller and you sell around a school, we don't like that either. You want to sell drugs? That's bad enough. But you can't sell them around the school, and you can't sell them to kids. You sell drugs to kids, you're going to get hit harder by statute. You sell drugs within a certain distance of a school, you're going to get harder. And honestly, though, when you think about that, there are not a whole lot of places you can go in Madison County that aren't far from schools. There are a lot of schools around here. You also have increased punishment for certain offenses like trafficking in drugs. You have drug sales, but then if you have a drug sale with a tremendous amount of drugs, that is what we call trafficking. You get your trafficking, you have a minimum mandatory of 3 years on the baseline. That means there are 3 years you got to serve no matter what. Although it may be 10 and above as your punishment, there's 3 years you have to serve, day for day, without any probation, parole, early getting out, any of that stuff. And one of the other big sentencing enhancement provisions are for sexual predators. You know, we talk about things we don't like. That's one of the things we really don't like. The law has come up with some very steep enhancements for people who commit sexual offenses to children under 12. We're going to talk in a few minutes about things that take away from your sentence. You don't get any of those. Any of the things we're about to talk about, you get none of those if you commit a sexual offense to someone 12 years and under. That minimum sentence on a Class B, instead of being 2 to 20, it is 10 years is the minimum. And that's 10 years to serve. Whereas, you know, you give someone a sentence of 10 years normally. I keep telling these stories. Another time, just talking about that 10 years, it made me think about one. Another time, right when I was fresh as a criminal defense attorney, I had a client, and he was sentenced to 10 years. And this was in the summer, maybe July. Christmas, I'm shopping, and I see him. He's walking around. He just got sentenced to 10 years, and he's walking around. And I go, oh my, do I need to contact the bar? And can I say I saw him? He's escaped. This guy's out. No, he hadn't escaped. One of the things we're going to talk about in a few minutes is they have things to let you get out early. And, you know, that's another thing as an attorney you have to make sure you are fully aware of and you fully know. And the first of those is what we call good time credits. There is a statute in Alabama that says for time you spend in the penitentiary where you're good and you don't get in trouble, they will give you credit on your sentence. You know, like Some of it can be pretty high. I was looking at the chart. A year. If you spend a year, you might get 6 months credit on your sentence for not getting in trouble. Think about that. So that's one of the reasons in Alabama we don't have what's called truth in sentencing, because when a person is sentenced, we don't know what they're going to get. I always tell my clients, if you're sentenced to 10 years, you need to be prepared to do 10 years. But folks get out really early sometimes. In addition to good time credit, you have parole. Parole is different from probation. We briefly touched on probation a few minutes ago. With probation, that is normally done either as a part of a plea agreement or it is done by the judge, but it's done at the trial court level. You get some time. That time is suspended. You're placed on probation. You report monthly to a probation officer. You don't go to jail. With parole, while you are in the Department of Corrections, they have a board. It's called a parole board, and it is strictly up to them. The parole board can decide to let you go home even though you are still considered to be in the Department of Corrections. You are under the authority of the Department of Corrections, but you're out. Now, with parole, it's a little bit easier to revoke you even than probation, because you are under almost a complete authority of that parole board and that parole officer. But some aspects of it are similar. You're going to report to a parole officer. You can't commit any new offenses. You cannot be around people of ill repute. You cannot commit injurious activities, is I think maybe the language they use. But parole gets you out earlier. We also have something called community corrections. Community corrections is actually the newest thing. Community corrections, it's sort of like ankle bracelet. You are still in jail, but your jail is your mama's house. You get that ankle bracelet on, and you can't leave within a certain footage of that house. If you do, an alarm goes off, and your community corrections officer is made aware that you have. Now, to me, if I'm in jail, I've got some big sentence over my head, and I'm in jail and I'm eating this horrible food, and I'm sleeping worried about somebody beating me or whatever, and I can go home, stay in my mama's house or my wife's house or my girlfriend's house, whoever's house. I can stay in that house. And of course there are other restrictions, but the restriction is you can't leave. I'm taking that. My mom can come and cook for me. My girlfriend can come by. My kids can come by. Folks can see me. I can watch cable TV. I can get a bath. I can do all that. But what you see happen, and it's amazing. People leave. Oh, I had an argument with my girlfriend, so we had to go and I had to see what was wrong with her. You better call her on the phone, because you can't leave. This is even worse than being revoked from probation. This is worse than being revoked from parole. You are still in jail. The jail is the house. If you leave the house, the analogy is you leaving the penitentiary. When you leave the penitentiary, you get an escape charge. You leave the house, not only are you going back to jail, you're getting a new felony. Sentence enhancement, clearly you've got one felony already. So you're not going to get a good sentence. You're getting another sentence. It can run either, and I didn't even mention this, it can run either concurrently or consecutively. Because anytime you get more than one sentence, there are two ways they can run. Concurrently, they can run at the same time, or consecutive. You can get one sentence, and then when that's over, you can run you have to do the next. So people can get out a number of different ways. And one of the reasons they do that, like I said, financially, there is a worry that we are going to be taken over by the federal government with our prison system. It's overcrowded, it's underfunded, it's populated by a number of nonviolent offenders. the things that the things that we talked about as far as people getting out of jail, those by and large are for people who are nonviolent offenders, because we're looking at ways to get nonviolent offenders out of the jail so that there can be room for the people who commit murders, who commit robberies, who commit rapes, who commit the violent crimes where there are serious physical injury to people. So as I said, we're trying to get people out and get the jails a little bit less full. In fact, recently, the state of Alabama has come with a new way of sentencing people. We have sentencing guidelines, and the DAs work out a formula. And with this formula, more and more people are been given probation recently, and less people are going to jail. It takes a lot of the negotiation out of it, because a lot of, as the lawyers in here will tell you, a lot of lawyering is talking. It's building relationships and going to talk to people. In criminal cases, you better know your prosecutor. If I'm a defense attorney, I need to be able to call my prosecutor and I need to be able to say, hey, look, there's something you need to look at in this case. And the prosecutor needs to be able to trust me. And that's something that's built from years of working together. He needs to know when I say A, it's A, and when I say B, it's B. Because the first time you as a defense attorney misrepresent anything to a judge or to a prosecutor, your reputation is gone, and you don't get that back. The only thing you've got is your reputation. So when you guys are out looking for an attorney, you know, so almost like when you look for a doctor, ask other attorneys if you know. Reputation is really, really key. In addition to what we talked about as far as people getting out early, there is, you also have what we call status offenses. Usually that's youthful offender. I don't think one of the things we're here to talk about today is juvenile court, but in summary, juvenile court is for children 18 and below. They have their own separate court, their own separate system, their own separate punishments, their own separate jails. Everything is completely different, and we could talk for hours about the juvenile system. But in sum, the law has said that if you are under 18, as a general rule, you do not have the capacity to form the intent to commit a crime. Thus, you are found to be a juvenile offender, a bad child. After you turn 18, but before you turn 21, you will be in state court. But you can make application to be treated and have some of the same benefits. It's called youthful offender. With a youthful offender, although you may give up your jury trial, you may have to have a bench trial, your range of punishment changes. The maximum you can get on a youthful offender is 3 years. Remember we talked about A, B, C? Maximum you can get is 3 years. In addition to that, and the most important thing, is your records are sealed. You get some guy, whether they're convicted or not, let's say you get some 19-year-old kid who is arrested for a robbery in the first degree. Whether he's convicted or not, you need to try and get him that youthful offender. And sometimes it's even more important if the case is dismissed. I've got one we're trying to get youthful offender on right now. The case was dismissed. It was dismissed by the grand jury, what they call a no bill. If we have time, we're going to talk about that. But he's 19 years old, and I'm going, well, Judge, I need the opportunity to apply him for youthful offender. His case was dismissed. He doesn't need every time he goes to apply for a job to have to explain, yes, I was arrested for this, but the charges were dropped. The youthful offender will keep out the arrest, and it will keep out the conviction. You will not. You are treated not as a delinquent child, a bad child, but as a youthful offender. Yes, sir.
Is it possible that somebody is 15 or 16 and be tried as an adult?
A person 15 or 16 can, in some instances, be tried as an adult. Usually, those are going to be the more violent offenses. There was a murder in one of the schools not long ago. I remember the victim's name, Todd Brown, but I cannot remember the offender's name. Okay. And he was charged as an adult. My recollection is he was somewhere around that age range. There are certain ways that a person under 18 can be charged as an adult. Usually it's either the nature of the offense or it's if he has committed so many offenses as a juvenile that they have made a determination that there's nothing further that the juvenile system can offer. The juvenile system is more about rehabilitation than punishment. Supposedly, the twin aims of the criminal justice system are rehabilitation and punishment. I think we're a little heavy on the punishment, but in juvenile, it's rehabilitation. So they have steps that they go through. The first time, you may be lectured and released. The second time, maybe boot camp. The third time, and it goes up. After a certain period of time, there's nothing further that can be offered. You have participated in every program, and they certify you. There's a process where they certify you as an adult. And so you will move up to adult court, and you'll be in big boy court dealing with the big boys, even though you're a little boy. And unfortunately, I mean, it really is sad to see sometimes. You see these little kids, and they are there, and they have to deal with, on a nightly basis, some big, scary folks.
The corollary to that is somebody who commits a crime as a child and is now 25.
Okay, let me repeat what you said. You said the corollary to that is someone who commits a crime as a child.
Under 18, 17, 18, and
And
not
is
tried
not
till
adult.
they're...
Now, keep in mind, if you commit, and I haven't had that one come up, if you commit a crime as a juvenile, I'm not sure if you would be tried if you're arrested at 25 as an adult or a juvenile, but you've got to look at a number of things, including the statute of limitations. For most of those offenses, if it's that big of a time gap, I would think that there would be some type of a statute of limitations that would prevent the case from being brought. If it is serious enough where the statute of limitations wouldn't run, and usually that's going to be on something like a murder, then that's going to be a case where they could have been tried as an adult in any event. The other thing to keep in mind with that, sir, is a practical matter. If you wait years to try a case, the longer you wait to try a case, the better it is for the defense. You know, witnesses' memories are not quite as sharp as they were. People are not quite as sure. Witnesses may have moved to other areas. They may be deceased. There are a number of things that make trying cases later, I think, more difficult for prosecutors. I think we've talked a little bit about the status offenses. I was going to try and talk about the way the system went through. Honestly, I didn't think this would go as quick as it did. We're going really quick. So we're going to talk. I'm going to try and just shoot through this with the initiation of a case. Normally, they're initiated by a complaint. An officer with a felony usually brings the case. It is going to be brought by the officer because he has either witnessed it himself or he's an investigator and you have gone and made some complaint and it's been investigated and they've made a determination that most likely that this event did occur. You are then arrested. Within 72 hours, you need to have a bond hearing. You need to have a bond set. If you do not have a bond set within 72 hours, the law says you get a minimal bond or the minimum amount of bond in the range. At some point after that, usually you're going to have an attorney retained to represent you or appointed to represent you. One of the first things that attorney needs to ask for is a preliminary hearing. In Alabama, we have a preliminary hearing and the grand jury process. The preliminary hearing, in some states, it's called a probable cause hearing. It's the hearing where the state is required to show that there was probable cause for the arrest. What's bad about Alabama is if you can show that there was no probable cause, the prosecutor still has the discretion to go forward. Had a case. Lady's charged with theft, stealing from her brother, right? We come in and show the officer, look, we've got, here's what you said she did. Here is her power of attorney to represent him. Here's his medical stuff that shows she's doing it. She can have his power of attorney because he has mental illness. Here's the check you said that she wrote, that she used her name. It all showed that there was no crime committed. But the prosecutor said he still wanted to go forward. So this person who's been arrested, if we get the judge to say that there's no probable cause, the prosecutor can then go and arrest them again. And they have to go through the booking process again and bond out again and still have to try the case to a jury, which I think is just the most wrong thing in the world. And I really, really want to apologize to you. I had all these things I wanted to talk about. I didn't think I'd be up here but 15 minutes, and I ended up doing it for a full hour. I hope I was able to impart something on you, into you as far as the criminal justice system, and I really appreciate your time.
Thank you so much. Thank you so much.
Yes, sir.